we can be very emotional and sentimental because of the background. But I like to be very, very honest and frank in dealing with any given situation. I have read the press release of the special prosecutor. Mm-hmm. And I want to say that we are not small children. Read his statement. What does he say? In paragraph 3. While the Office of Special Prosecutor respects the court's decision, it disagrees with the decision of the court. First, the OSP believes that the court's computation of the time limitation is, with respect, erroneous. That's actually the most critical paragraph in this statement. The OSP searched 3 private residences associated with Ms. Dapaah over the course of 2 weeks. The searches and discovery were ongoing during that period. There is little doubt that the OSP filed its application within the statutory window once the search and discovery window is considered. You see, I am not a fan of Cecilia Dapaah. I don't think what she has done is right. But I was in Parliament and I participated in passing this law. If you look at Section 32 of the Office of Special Prosecutor Act, 32(2). 32 gives the special prosecutor or his agent the powers to seize.
To search and seize.
Search and seize what is suspected to be tainted property. Okay? But 32(2) says that the special prosecutor shall apply to court within 7 days. Within 7 days to confirm the seizure. This is somebody's private property. And if you take it, we say run to court within 7 days and confirm the seizure.
That's in 32(2).
Yes, confirm the seizure.
The special prosecutor shall apply to the court on notice within 7 days to confirm the seizure.
Exactly, that's what the law says. Now, this third paragraph, convoluted. There's nothing in that paragraph in which the special prosecutor is saying that from the date to when we ran to court to apply for the seizure, it was 7 days. We're not talking about when you went to search the property. We're not talking about how many properties you searched, whether you searched 3, 4, 5, whatever. Whether it took you 1 year to do your searches, it doesn't matter. The specific date that you seize this particular item, that is the date we are supposed to start counting from. After 7 days, if you haven't gone to court to confirm it, you have breached Section 32 of your own act. So he shouldn't try to throw dust into our eyes. If you are negligent, admit that you are negligent. If you haven't performed your task as expected of you, admit that you have not performed your task. The judges are there to protect the rights of everybody, just as to also ensure that you exercise your powers properly. So did the special prosecutor run to court within 7 days of seizing the property or not? That's the crucial question that has to be answered by the special prosecutor. If he did not, why didn't he? In the face of 32(2), which clearly says that for him to continue to hold that asset, he must go and have it confirmed by a court. If he didn't go, he can't come and be throwing dust into our eyes. And if he didn't go, he only knows what motivated him not to go within the statutory period.
32(3). If you read further, it says, where the special prosecutor fails to prefer charges within 60 days after the seizure, the special prosecutor shall release the seized property to the person whom it was seized. How do you reconcile this with 32(2)?
No, it's very simple. You see, you seize property not because you have convicted somebody. You seize it in the course of investigation. So we're not saying that you must have concluded your investigation before you seize property. No. In the course of the investigation, if you have reasonable cause to believe that this property is likely to be tainted, then you should run to court after 7 days of taking the property to say, look, I suspect that this property is tainted. Look, I'm investigating her. She was a minister of state. Every year she had a budget of $100 million to make sure that the city is clean, and then, you know, water contracts are awarded. She awarded, you know, contracts for the cleaning of the lagoon and etc., which cost, you know, $100 million and etc. So she managed public money. Okay? Now we found money in her house. We suspect that it could be the proceeds of corruption. But we are still investigating. So can you allow us to keep this money so that we can conclude our investigation? If we conclude that no, she has given sufficient explanation for the source of the money, we'll give her money back to her. But if she is not able to give sufficient explanation, we're going to prosecute her. And whilst we are prosecuting her, please allow us to keep the money. Otherwise, if you let her hold this money, get hold of this money, and then we convict her, and then we go to now seize the property because it belongs to the state, and then it is no longer there.
Is the special prosecutor not telling you that?
Listen,
you by how you say it should be computed.
Yes.
That is where the court is wrong.
No, the court is not wrong.
He's saying from here.
Yes.
That if you are taking our last day into consideration,
yes,
then we did 2 weeks of searches.
No, I'm saying that.
Which 2 weeks of searches? You should not be counting that. You are saying it is the last day, the day you declare the property as seized.
The issue is not searches. The issue is the moment that you seize, you took possession. Yeah. Seizure is when you take possession of the property.
It's not when you declare that you have seized
it. When you took possession of the property, and when you deprive the owner of possession of the property, that's the moment at which you have seized the property.
Okay, so this last one, let me bring in this last one for you to help us, because I had referred that to...
Go to the definition of seizure.
I'd referred that to Osman too. Regulation 15 of its regulations.
Yes.
Seizure and detention of currency suspected to be proceeds of corruption.
Yes.
Where an authorized officer seizes currency suspected to be proceeds of corruption, that authorized officer shall complete a currency seizure form as specified in Form 4A of the first schedule and issue a currency seizure notice in accordance with Form 4B of the first schedule to the suspect pending investigations. The form says Form 4A and B. Form 4A, it just says give your name, whatever, the type of currency, the amount of money, the denomination, and the condition the money is in, and so on, and the day in which it is taken. Then the Form 4B says currency seizure notice. So you give this to the person. It says take notice that the under mentioned amount of currency is liable to forfeiture, and you should, within 1 calendar month from the date of this notice, give notice in writing to the office. In default of such notice, the currency shall be deemed to have been lawfully forfeited to the state. If you give notice of claim or intended claim within the time specified above, legal proceedings for the forfeiture of the currency will commence. How do you take this in addition to 32(2)? It says give them a notice, seize the currency. The notice is for 1 month, correct? 1 calendar month. And it says within that period, you whose money has been taken, you must make a claim. If you don't make a claim, the money is deemed to have been seized to the state.
You see, the Parent Act makes provision for the person seizing the property to notify the person's property, the person whose property has been seized.
That's right.
And give an account of exactly how much has been seized. There's accountability mechanism there. So the regulations is simply trying to define the mechanics of achieving that. For me, that is not the issue. The issue is when is a property seized? It is seized when you take possession and deprive the owner of possession and control of the property. That's when a seizure has taken place.
Okay.
When must you apply for confirmation? You must apply for confirmation within 7 days. I'm saying that the special prosecutor did not do that. He has been negligent. Okay. He wants to throw dust into our eyes.
Thank you.
By issuing these long, convoluted statements.
Yes. And
the courts are there to protect everybody.
The conclusion is...
So let's not blame the court.
The conclusion is what I'm asking your view of, and I'll go to Amanda too about that before I come to Richard. He says he assures the public that it will take all necessary legal steps to ensure that the seized amounts and the balances in her accounts and investments are neither concealed, lost, or dissipated.
I disagree with the court. It's not that I agree with the court for rejecting the application.
Oh, how?
No, the reason is simple. That, you see, the court should have a discretion to say, well, you've come late. But every evidence here shows that it is likely that this is tainted, property. So even though you've come,
the court not be prejudging the whole matter.
Exactly.
Oh well, I mean the suspicion of reasonableness. See, the judge has to take a decision that yes, it's reasonable to suspect that this is tainted property. Okay, the judge does not conclude that way. The judge says that no, I disagree with you. I think that you just came here because of public sentiments. How's that? We all know the facts.
Is
it not? Is a public sentiment wrong? Is it not founded on facts? The public sentiment is founded on the fact that this is their Minister of State. Annually, through her period as minister, she was given huge amounts of money to manage public assets, acquire assets for the public.
All right.
Is that okay? Now, we have found millions of cedis and dollars in her residence. In fact, she is the one who first complained that some of it has been stolen. And from the fact, she doesn't seem to know exactly how much of it was stolen. Then, special prosecutor comes in, and then they found other monies that are not kept in the bank, monies that are kept at home. So, prima facie, any reasonable person, but why are you keeping such huge amounts of money at home? Why? Why are you hiding it?
What's the crime in that?
No. Well, it raises suspicion. If you, a private legal practitioner, you decide to keep $10 million at home, and we come, is it our business? All we'll be asking for, okay, well, where did you change the money? Give us the Forest Bureau at which, you change the money. Or give us the bank.
Because he's a public officer.
Because you're a private person. You're running your law firm. Okay? Unless maybe we suspect you of doing drugs or you are doing money laundering. We may ask you where's the money coming from. Maybe you should ask,
I need just 30 seconds.
Briefs in which you are
just 30 seconds on
millions of dollars.
I need just 30 seconds on this. Do you think that it was fatal somewhat to the OSP when it didn't exhibit, for example, the accounts it was freezing, to say that we have seen this transaction. This transaction is suspicious. We have seen that transaction. This amount came from X to this account. But
you see, if it is money in an account, okay, you will expect that the special prosecutor will first check to see where is the money coming from. So if there's a transfer of money, and then you will ask the person, what is the source? What transaction generated this transfer? So if she sold a house she inherited from her father,
she'll explain.
And then she explains, oh yeah, I sold this house, these are the documents.
There'll be a narration in the account.
The buyer is in London, he transferred the money to me. The narrative is there. If there's such a narrative, on what basis are you freezing that account?
Okay.
So the fact that you suspect her of having committed offense doesn't mean that her entire economic and financial life should be strangulated.
So my question is that was it fatal not to exhibit the account statement to point out and say, I've seen this transaction?
I think it is.
It was?
I think it is. I think it is derelict on the part of the special prosecutor not to have at least done some basic analysis of the account statement to be able to ascertain the sources of the monies in the account.
Thank you very much.
I will treat the monies in the house differently
from
monies that are found in an account in the bank.
Thank you very much.